Putting it in the chair.
Thank you.
I'm gonna act as the owl today, so I'm just gonna.
Thank you. Welcome, everybody. We're doing a hybrid meeting of the BCA. My name is Linda Gray, and we have folks, more folks are present here than on Zoom. And I just want to let everybody, because you can't necessarily see the whole screen well, but to know on Zoom, we have Michael Adams and Tony Adams, who are the appellate party. And then Marcia Callaway is here with us as a BCA member via Zoom. And so let me go ahead and get started. So our agenda, we first want to do minutes.
Yep.
And that will be very, very quick. And now with Zoom up, I can't see the other stuff. So we have two sets of minutes from May and from June, right?
Two from May 7th and May 15th. So we need to amend the agenda to approve both of those minutes if people.
Oh,
would like.
okay. So the agenda went with just one set of
Nope, it
minutes
went-
noted.
Right, the agenda went out with one set of minutes noted, but there are
Yeah,
two in the
so
packet.
we want to, first of all, we want to approve the agenda
The agenda would have.
with a notation about one set of minutes being on the agenda to be approved. So we want to just very quickly amend the agenda. If somebody can move to amend the agenda to include May, which date?
7th.
Oh, what's the, yeah, why don't you do that?
I move to amend the agenda so that item number 1 reads approval of 5/7/24 minutes and 5/15/24 minutes.
Okay, a second? That's a leaks, okay. And all in favor, raise your hand. Any opposed? I see, oh, Marcia, you are opposed?
No, I'm not. I think you have to take a roll call.
Oh,
But
okay.
let's finish this and then take the roll.
No, she
No,
needs
no,
a roll
she's saying
call
for
vote.
this. Okay, so David, can you give us your vote on the amendment?
Yes.
Suzanne? Yes.
You don't have to.
And this was Elise, Linda, yes, Arlene,
Yes,
and Fran,
yes, I guess.
and Lily.
Tryman, yes.
Okay,
And Marcia, yes.
Marcia, thank you so much. Okay, so we've amended the agenda, and now can we have a motion to approve the agenda? Oh, Arlene,
I'm going to approve the agenda as amended.
okay, and a second. Suzanne, all right. And any discussion?
There's an error in one set of minutes.
Well, this is just, no, then next we'll actually approve it. Okay, so you're fine with the agenda as amended? I take it, okay. And Marcia, I need to keep doing roll calls for all these things? Is that true? Okay.
Right.
Thank you. Okay, David, approving the agenda.
Yes.
Suzanne? Yes? Okay, say it out loud.
Yes. Yes.
Linda, yes?
Yes.
Arlene, yes? Fran? To approve the agenda?
Yes.
And Lily?
Tryman, yes.
And Marcia?
Yes.
Yes, okay, all right, so there we are, and now we approve the agenda, now we're gonna approve the minutes. I hope so, let's have a motion to approve the minutes. Who wants to do that?
I'll move to.
Arlene, okay, and a second?
The
I
minutes
don't want to approve the minutes because they're.
of both meetings, are we doing one? at a
We
time?
discussed after the second.
How can you approve
No,
them?
I'm sorry. No, you're right.
I don't want to approve them because there's an error in one of them.
Okay, so we want to make a motion to approve the minutes. And we can, let's do them one at a time, it'll be simpler. So let's go with 5/7.
Okay, I move to approve the minutes of May 7th.
Okay, and who will,
Which minutes were those? I don't have them in front of me.
Could you speak a little louder?
but first let's, how about a second? Somebody second. Lily, thank you. And now let's have discussion. So is this a set where we have a correction?
I think they're frozen.
Marcia, what are you saying?
I thought you were frozen. I couldn't hear anything.
No, we haven't. We just have a motion on the table and now Elise know that we're having discussion. Elise knows that she has a correction for one of them and she's trying to identify which it is. So right now we're kind of awaiting discussion of 5-7 minutes. Does anybody else have a correction on that, by the way? No, okay. Is this the set that you have?
This is a correction to what will end up being both sets of minutes. It says that we're doing a site inspection of the Grange and that Robin, Clinton, and Leiter were going, and it turned out to be Robin, myself, and Suzanne. So Carolyn Clinton didn't.
Oh, okay, so you want to correct the inspection team list to replace Carolyn Clinton with you, right? Because that's what happened. Okay, yes, and I'm assuming we're fine with that change.
Well, I have a question.
Yes.
Was that change during the meeting or was that change as they did it?
Carolyn Clinton wasn't involved.
Yeah.
I think
She
it
never
was,
like-
yeah, I think it was a correction in the meeting.
Yeah.
Okay, so with that change, is everybody ready to approve this set of minutes? Let's roll call. David?
Yes.
Dan?
Yes.
Alix? Linda, yes. Arlene?
Yes.
Fran? Lily? Marcia?
Yes,
Okay, all right. Now we need approval for, and it's 5:15. Who will make that motion?
I move that we approve the minutes of the May 15th.
Okay, who wants a second? Yay, thank you. And that same point is in both sets of minutes, right, Alix? Or,
I thought it was.
okay. So perhaps no correction to these minutes?
It just says inspection committee, but it doesn't identify.
Okay.
what goes on it, so.
All right. No further corrections from anybody? All right, we ready to vote? Let's do the roll call again. David?
Yes.
Suzanne? Yes. Alix, yes. Linda, yes. Arlene?
Yes.
Fran? Lily? Yes. Yes, and Marcia?
yes,
Okay, perfect. All right, all done. Yay. Okay, now we can turn to the hearing on the Adams appeal. And so, and I want to just say the appellant is James Adam. The property parcel ID is 03-040.000. Is that correct? Thank you. It's on Chapel Hill Road. And I just want to confirm the appellant has received a copy of our rules. You are,
Yes,
you know,
yes.
important.
I have a copy of the rules, yes.
Thank you. Do you have any questions about how we'll proceed?
No, I see the outline of how it will proceed is in the rules too.
Okay, perfect, thank you. Okay, and so what we'd like to do very briefly is for your benefit, and hopefully you'll hear voices. I don't know if you're gonna be able to see absolutely everybody, but let's just introduce ourselves, the members of the BCA, to you. And so I'm gonna start with this end of the table where it is Steve. So introduce yourself, Lily.
Hi, I'm Lily Tryman. I'm the town clerk. We've corresponded.
Yes.
And next,
Yeah, I'm Francie Gass, I'm a JP.
and I'm the great justice of the peace and chair of the board. Please, Manny, justice of the peace. Dan Ryder, justice of the peace.
Dave Kreml, Justice of the Peace.
You and all present are.
Marcia Calloway, Select Board.
Oh, Marcia, thank you so much. My apologies. Keep reminding me that you're there. All right, thank you. And then also present, we have Ernie Chikatowski and Cheryl Lindbergh, who are listers. I'm sure that you've met, and also our town manager, Brennan Duffy. So we want to ask, do any BCA members have any conflicts of interest or ex parte communications? And if so, you have to disclose them now. Okay.
So I'm going to recuse myself from this hearing because I attended the select board at which this was discussed. And I believe, despite legal counsel, feeling that this was a discussion that took place not at a BCA hearing. So I feel more comfortable not participating, although I will stay and take notes unless anyone objects to that.
So you'll function as the clerk?
I will function
but
only
not
as the
the-
clerk. I am a non-voting member and I will not weigh in.
Okay, well, that's fine. That's up to you. Okay. Then, what our rules are, and I would like to say, I think we have received very good summaries from both parties. So I would like to encourage everybody in the period where you get to explain your points, that you do an elevator version of it, so that then we have more time for questions, and you can refer us to portions of the materials that you provided us that will give us the answers to our questions if we have them. So I'd like to just try to make the time you take for presentations be very straightforward and short, so that we have more time for questions, if that seems fine. Yeah.
That's where the minute.
Yes, I will. Yes.
And just wanted to quickly ask, I didn't see in the paperwork from the Adams's family, since this is James's property, where he authorized his father to speak on his behalf. Was that something received that I missed?
Yes, Cheryl. James did sign something which was sent to Lily. Gosh, maybe 2 weeks ago. It was right after, we got the notice of the meeting, and it was right then, because he had a small window where he was not in the field where he is now. But so
Okay.
Lily has a copy of his signed delegation of authority to me to appeal on his behalf.
I can pull that out if anyone wants it.
No, I
Okay.
Okay.
just wanted to ask.
The other thing, before we get into the presentations, I do want to do the oath for everybody who's going to be a witness here. And so I want to do that verbally to both listers and both parties here on behalf of the appellant. And note that you all have the form to fill out in person there, and both, and the Adamses have done it? Yes, fine. So we're good on that. But let me do it verbally for you four. So the oath is: under the pains and penalty of perjury, do you solemnly swear that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth?
I do.
I do.
And Tony, yes? Okay.
Yes,
Thank
I
you.
do.
Thank you. Okay, so we're going to ask our first step is just have the listers introduce the property that's the subject of the appeal, describe it, and its present valuation.
Well, the subject property is parcel 03-040.000. I believe in the documentation we got from Mr. Adams that there was a reflection of the valuation of it. Am I wrong? They did not bring.
There is
All right, the valuation is 99,100. It's on the tax bill that is.
So it's acreage and no.
Acreage is 10.4 acres according to our records. And the valuation is 99,100.
And it's simply land,
Correct.
okay?
Correct.
All right. Thank you. And so, and now we want to ask the appellant to present more evaluation supporting evidence. And again, what I want to say is, I think you provided very good written materials for us. So you don't need to like read that to us, but if you would just do, what I'm going to suggest is do like elevator version of it so that then we can question. If that sounds fine, could we hold on a minute, Arlene?
I think that, because this is quasi-judicial hearing, we have to accept all of these things as evidence and lock them as evidence.
And that's not been a usual procedure for the BCA, but I'm happy to just say we have, and so let me I gotta switch gears out of Zoom and say the materials. Let me just enumerate what we have, what Lily distributed for us. So we have a packet from the listers. We have the Adams' appeal document, supporting testimony document. So there was 3 particular files, and I would say that we have, this is what we have, this is the evidence that that's been submitted, written evidence that's been submitted to us.
I reread, the
Our-
workshops on, property tax appeals,
Right, and so you think we
procedures,
should
and
have.
that's where I read
Okay.
that everything could be submitted and marked as. So if we don't do that, we don't do that, but that generally puts it in trouble.
And that's fine, do you want to be formal and make a motion?
I
I'm happy to
move,
do that.
I move that I'll do them one at a time, the documents presented by the Board of Listers. Be entered into evidence, 1 document, 2 documents?
It's one, it's
One, and be
multiple
marked
pages.
as exhibit 1.
Well, or as given, let's just call it lister packet, let's
Okay.
go with the names that the PDFs have. Let's do them all at once, let's not do 3.
Okay, and then the documents that have been held.
Right, and so there's one that's called, it's got the date, and then it says JHA BCA appeal document. So that is one, there's the next PDF, this has got the date, it's 2024-09-04, TA BCA witness testimony signed. So, those are the other 2 documents from the appellants.
Okay, I move that those be admitted into evidence
Mhm.
and be marked as exhibits.
Okay, and a second, please. Suzanne, thank you. And is there any discussion about that? In which case, let's vote. So roll call, David. Just admitting into evidence the packets that we received, the PDFs that we received. David. Elise, yeah. Linda, yes. Arlene.
Yes.
Fran. And Lily? Oh, no, you're not voting. And Marcia?
Yes.
Thank you. All right. Okay, now, here we are. And so either, Michael, are you going to take the lead?
Yes.
Thank you.
Okay. All right. Thank you all for being with us tonight. I apologize for not being there. I'm on a long scheduled vacation in Europe, so that's why I'm not there. My son, as I think some of you understand, is on active duty in the U.S. Army. He's currently, as we speak, in the field training and is incommunicado for the next 2 months. So that is why he delegated to me on his behalf. I sent a document which you've just admitted as evidence, and I think the 2 issues are the amount of acres and then the value of the acres because the land is undevelopable and is really just a woodlot. So those are the 2 issues. We have a survey which shows 2.4 acres. We have a deed that says that. We believe that those are the primary source documents. Tax maps of a town come with large disclaimers when you go online and look at them. And those disclaimers say they're not to be relied on. So we believe that our documentation is correct, is primary, and should be taken, and that the tax map should be corrected to put it back to 2.4 acres. With that, I'm going to pass it to my brother, Tony, who's the previous owner of the land at the, and he, as you can see from his statement, which I guess he'll summarize briefly, he was involved in all these previous discussions. And so I pass it to Tony.
Thanks, Mike. Linda, may I confirm that everyone has a copy of the survey available to them? This is kind of the primary document that I'll be talking about.
And I believe, let me just check that would be in.
It's attachment 1, page 4 of my document. And if you'd like to do a screen share, perhaps we can do it that way. I'm not sure what is most readily available for people in the room, whether it's the computer screen or paper copies. But I'd like to make sure that everyone can see it as I speak very briefly about it.
And I'm looking around and it looks to me like everybody has something that they can look at. So I think
Okay, that's great. Thank you so much. I would just like to call your attention to the acreage this is acreage that I purchased back in 1999. I purchased it because it's adjacent to old family property that at the time was in the hands of my grandfather. It's a house on Sugar House Road that was built by Mike's and my great-great-great-grandfather Simons back in 1858. We wanted to keep it in the family, so I bought it in 1999 from a gentleman named Charles G. Davis Jr. At the time I purchased this property, I was given this survey that was commissioned by Mr. Davis by DiBernardo Associates. And as you can see, the survey indicates that the property is split into 2 parcels, okay? Importantly, there's a small parcel on the east side of Chapel Hill Road that has an acreage of 9.82 acres. And on the west side of Chapel Hill, there are 35.2 acres, of which he says approximately 2.4 acres are in Norwich. And so that is what I purchased. And it was on that basis, the acreage numbers that you see on that map, that I started paying property taxes starting in 1999, rolling through forward to 2000, well, all the way through, frankly, until I transferred the property to my mother in 2012. However, as I noted in my testimony, in 2004, there was a valuation bump that I received that I didn't quite agree with. And so I reached out to the then zoning administrator, Phil Deckert, to help me survey what the developability of this land might be. And he helped me to write a memo at that time in 2004, which described the property in Norwich as 2.4 acres. And he went on to say that because of the slopes, because of the water feature, the property is only is not developable. But I do want to reiterate that at the time, the Norwich tax maps that he referred to and this memo that he wrote referred to 2.4 acres. So, he was very helpful at the time to write that memo, which is also in my testimony document. And at the time, my grievance on the valuation was actually supported. The listers then backed down and they agreed with to keep a valuation assessment at $2,400 for the 2.4 acres. Okay. Fast forward to 2007, out of the blue, I get this notice that all of a sudden it's going to be 10.4 acres. I was not told how this acreage had been able to grow so big. I was not consulted on that. There was no new survey. The listers at the time did not say that my survey was bad, but they said that it's now 10.4 acres, just out of the blue, not in consultation with Sharon, not having followed the procedures that the listers today talk about in terms of trying to move a municipal line. They didn't go through that at all. I appealed that. I grieved that. My grievance was denied, and the letter that contained the denial was sent to me by post to my home here in Hong Kong, and I received it after the reply by date. And so since 2007, we've had this problem of double taxation. I repeat, double taxation on Chapel Hill Road. Moving forward, in 2012, I transferred the entire property that you see there in attachment 1 to my mother, Grace Ryan Adams. And then in 2023, she transferred the property that's on the west side of the road to her nephew, James, Mike's son, James.
Her grandson.
Yeah, her grandson, James, Mike's son, James. Back to the map, she transferred everything on the west side of the road, which is 35.2 acres in total, of which 2.4 acres are in Norwich. These numbers are quoted in the deed that James received through this transfer. That deed, as you see, is on page 6 of my testimony document. It's the Vermont warranty deed. Talks about the land on the westerly side of the road and that 2.4 acres are located in Norwich. Today, we don't understand why the listers are ascribing 10.4 acres to James. It was a mistake in the past when I owned both sides of the road. Now they're ascribing 10.4 acres to James. We don't understand why. As my brother Mike mentioned, the tax maps that the listers are using are rife with errors. They have massive disclosure statements when you click onto them. If you have an electronic version of my statement, you can click through on that link to both of the maps that I find on the listers webpage, talking about parcel data being general in nature and does not represent survey grade boundary information. So at this point, our family does not understand why the listers are unwilling to base their assessments on primary source information rather than these online maps, which are very out of date, by the way. Norwich is in the brown recency category in terms of providing the state updated digital information about its geography. The other point we would like to raise is that the town boundary on the map that the listers have on the webpage, that is not straight. In fact, the town boundary, according to Norwich, and the town boundary, according to Sharon, waves back and forth, crossing each other at least twice, such that down in the Tigertown neighborhood, there's a patch of land that, according to these online maps, is not claimed by either town. So clearly there's mistakes. Clearly it needs to be cleaned up. And if one were to look at the primary source data, I'm sure one would see that land is claimed by landowners who think that they're in one town or the other. The listers to this day have been unable to articulate to my family which 10.4 acres James owns, or even what the size or what the shape of such a hypothetical parcel might be. This is all a taxation problem. It's a double taxation problem that then morphs into an even larger financial problem for my elderly mother, who still retains that 9.82 acres on the east side of the road. Because of this cloud of ambiguity, the land is effectively unmarketable. No one will purchase it because their question is, well, you know, in the future, when I own this, a prospective buyer will say, when I own this, I don't want to be paying taxes to two different towns. If I build a property on this parcel, from whom should I get my building permit? To whom in the future would I be paying my property taxes on a homestead? So all of these problems have kind of resulted in our elderly mother not being able to sell her property, which is a large kind of financial concern for her, and it's very troubling for her and as a result for our whole family. Mention was made of the lister of the property card for James's property. It's about a year old now, and it has not been updated to show that James is now the owner of this property. We ask that the lister card be updated, and that all of these data errors that the listers have be corrected by the BCA today. On the subject of valuation, I'm not an expert in valuation. I was hoping that the listers in their packet would have something regarding valuation, which was point 2 of our request to the BCA to discuss today. In any event, I don't believe that the property that was worth $2,400 in 2024 can grow at, almost 21% over 20 years. It's probably 2004 cannot grow, to $99,000 today. That would suggest an annualized rate of increase of 20.45%, which is just, doesn't make sense. I did some research on the internet, and it looks like, a reasonable assumption for a long-term annualized growth rate for real estate in the United States might be something north of 10%, call it 10.3%. If we grow $2,400 for 20 years at 10.3%, we get a valuation today of $17,050. I repeat, $17,050, which is $7,104 per acre. That would be our suggestion for your consideration regarding the valuation of this property. That, in summary, is my testimony. I'd be very happy to answer any of your questions.
Okay, thank you very much. Do we have, so our sequence, and I'm okay with our sequence is you present your evaluation, etc. Then the listers can respond to that directly. Then we ask questions. And so I want to ask the listers to make a judgment. Do you have any different questions to ask that would not be part of your presentation? Like, do you want to, yes, you do? Yeah. Okay, go for it.
Yeah, a couple things that I would offer. If you look at the packet that was submitted by the Adams, you'll see the tax bill in there. That does reflect current ownership. That is correctly changed by the listers to the proper ownership. The tax bill just issue came out under James Adams. That's what we have from that. I just wanted to mention that. In terms of property record cards, the townwide reappraisal did not get completed, and we put it on hold, and therefore the only property record cards that we can issue right now are 2023 property record cards, because we don't have and will not have 2024 property record cards. The next ones that we will have will be 2025. And this is all part of that. So I wanted to mention that to you, and that the reason for the change back in 2007 that was referred to was that new tax maps indicated 10.4 acres. There was an opportunity to grieve this. That was the message sent to Tony Adams, Anthony Adams at the time. There was a correspondence. I understand logistically he was not in the States, but in Hong Kong. But there was the basis for the change from 2.4 to 10.4, where it was new tax maps were the indication from that change. So that would then change the value.
I'm not going to ask this now, but because I want to ask later. It's like, explain to us the new tax map, but don't do it now. That's a question for when you're making a presentation. Anything else in the motion? Then we'll get to questions.
May I have a follow-up?
Yes.
So in 2007, I did grieve, and the grievance is on file. My grievance was denied.
Thank you. Yes, we got that. Okay, so now, may I ask BCA members, if you have questions that you would like to ask? Yes, to the, yeah. Yes, good, okay. And, Lily, can you turn your computer so that we can see? Thank you.
Thanks. I'm wondering if you've also been in touch with the town of Sharon and if you're talking to them about this as well?
I'm sorry, I did not understand the question.
Have you been in touch with the town of Sharon since it's a boundary dispute? Talk to them about the double taxation?
No, there's no dispute with Sharon. The issue is Norwich increased unilaterally in 2007, unilaterally increased based on its tax maps, the amount of land that Norwich thinks is in Norwich from 2.4 to 10.4. Sharon never changed anything. So there's no, we don't have a dispute with Sharon.
Seems like there's a lack of understanding between the two towns then, if both towns are claiming a piece of land, and I just wondered if you've been in touch with them.
Well, as we say, our survey, which is under Vermont law, and perhaps at some point the BCA could consult the Norwich town lawyer to confirm what I'm about to say. But our understanding under Vermont law, I'm not a lawyer, by the way, neither is my brother. Our understanding of Vermont law, which makes practical sense to us, is that a survey and a deed are the primary documents upon which taxation should be based, and that the tax maps are a rather recent creation, and they're not as accurate, and that's why they're disclaimed on the websites, that you cannot rely on these as actually accurately representing properties. For that, you need to go to the survey and the deed. And so the survey and the deed is what we have. And of course, is what was in existence before 2007. And yes, Norwich apparently updated its tax map then, but that doesn't change what a survey and a deed say. I mean, that's just a matter of Vermont law, as we understand it, property law, which makes sense because what is it how do you prove ownership of your property? Well, you have a survey and you have a deed. That's how you prove it.
Thank you. And so to follow up, I'd like to ask Suzanne's question. So, and I'm not sure I have the numbers exactly right. A parcel of like maybe 37 acres, like, but the total parcel, and Sharon and you are in agreement as to how much of that land is in Sharon and how much is in Norwich. Like Sharon, listers say there's 2.4 acres of your property that is in Norwich and the rest is in Sharon. And so that's why you haven't got to them, because you are in agreement with them.
That's correct. And in fact, the state of Vermont agrees with Sharon as well regarding what acreage is where. So we're good with the state of Vermont. We're good with the town of Sharon. It's with the town of Norwich that we have a dispute over the taxation of this land that is reflected in the survey and the deed. We're not interested today in arguing a town boundary. Our request to the BCA is to consider the taxation of the property.
Wait, what do you mean by the state of Vermont agrees with you? Who, like what?
So if you look at, this is jumping ahead, but if you look at page 4 of, if you look at page 3 of the lister's packet, it includes a map. And there's a note on the map that says the town line according to Sharon parcel layer and state towns layer. It has another note that shows a town line, a different line, a parallel line further to the west that says town line according to Norwich parcel layer. My point being that the state of Vermont appears to agree with Sharon as well. So if and when there ever were a discussion about where the town boundary should be demarcated on the ground with monuments and iron posts and whatnot, it appears that Vermont is on the side of Sharon. But we're not suggesting that we adjudicate the town boundary today. We're requesting the BCA's assistance to make sure that the taxation on this property is appropriate and that we are not double taxed.
Okay, thank you. You have a question. This is Arlene.
I just want to see if I understand this. There is a town line in Sharon, and there is a town line in Norwich, and they do not, I don't think that they agree, nor, and I just want to know if I'm stating this right. And so there have been, there's all these things that have happened, but there's no definitive determination as to where that town line is. Is that correct?
We don't know, I'm sorry, we don't know that because
No, so don't answer the listers
So-
that. We're asking.
Linda, we're going way over time.
Right,
So
I
we
do,
need to-
yeah.
Okay,
So hold that thought. Are there other questions to ask the appellant? Excuse me. It looks like, no,
Hello?
right?
Hello?
You have a question, but
Martha,
you
Martha.
want to direct it. Yeah, Marcia, sorry.
Sure. So there's no deed that I can see and no survey that mentions 10.4 acres. Is that true?
That is correct, ma'am.
Thank you. And just one follow-up, the deed that passed from your mother to her grandson.
Yep.
That deed included and was filed with, or at least referenced, the DiBernardo survey from, what was it, 1997?
1990.
99?
It was done in 1990, but then it was kind of updated in January. It was done in December of 90, updated and filed in January 91. So sometimes it's called the 1990 survey, sometimes it's called the 1991 survey. What happened was my grandfather orally agreed a boundary corner, and Alan Britton orally agreed a boundary corner a few days after DiBernardo did the survey. And so the date on the survey is 11/5/90, and then these two oral agreements were reached in the first week of December. So he updated it January 8th, 91. And
So
that
the-
says 2.4 acres. It always said 2.4. It's only ever said 2.4 acres, and the deeds that are recorded in the towns say 2.4 acres.
And that's located on page 6 of my submittal, attachment 3, James's deed.
Okay, any other questions?
I have a question. If the whole thing is based on a boundary line dispute,
No, ma'am.
if that is not,
It's not based on, there's no boundary line dispute. This is tax maps were revised, and unilaterally Norwich seemed to think that based on revising a tax map, they could overcome our deed and our survey. And we just don't think that's right. It's not fair, and it's not legally right. And but you have the ability to fix this simple tax matter. We're not talking about moving boundary lines. There's no boundary line movement.
Thank you. Any other questions from BZA members?
Is this just for the
Okay.
appellants? Questions just for the appellants or questions for anybody?
Question for the appellant.
Okay.
Okay, because next we're gonna have a presentation from the listers and then we get to go through questions with them. But Arlene, you have a question.
whenever the property transfers were made within your family, and they were deeds, they were deeded, did anybody ever do a title search?
The answer is yes. For example, when my mother transferred to her grandson, James, my nephew, James, both sides were represented by counsel, and James's counsel did do a title search.
Linda, point of order. We have this room until 5. I don't know what comes after. I don't
Okay.
know if there is another thing at 5. but
Okay.
Just be aware.
Thank you. Okay, so any follow-up that, okay. So next in our procedure would be to have the listers make their presentation to us, so you do that, and then very quickly, you all can ask them questions if you want, then we ask you questions, and Lily is highlighting that we should aim as best we can for 15 minutes. In addition, we also need to end up scheduling an inspection.
Okay, we'll take off, we're going to, we're not going to recap a lot of this. I just want to say to you that we are very passionate about resolving this matter and have worked with the Adams family since March of last year on this matter, and it has been a great exchange of ideas and information. So just so you know, this does go back to 2004, prior to Ernie or myself being a lister. We're trying to help resolve something that has been unresolved for 20 years. We have all the information that we have to work from. That's where I found the grand list changes in 07, where in their particular case, it had to do with new tax maps. For the reason there wasn't a grievance, that they were denied. Any point after that, someone can grieve any year at any time. You don't have to accept 1 year's decision on any particular property. You can grieve any year you wish, and it would have been great if that could have been resolved back in 2007 and 2008, but it isn't resolved. I have spoken with the Sharon listers, and I will tell you with my oath of office that I took and with this swearing in here that I have spoken with the listers in Sharon. They do not agree with the boundary line, and there are other parcels along the map of the boundary line that they have turned their head the other way, saying, well, you know, this line, we've seen properties built, dwellings that should be in Sharon, but we've turned our head.
Well, wait, when you said they do not agree with the boundary line, you mean the north boundary line, or they don't?
The boundary line, their definition of the boundary line between our towns is different than ours. And that is why we cannot change the acreage, because in essence, if we change the acreage, we're accepting a boundary line that Sharon says is the boundary line. And if you read the email from the current contracted assessor, who told us not to do that because it's changing the boundary line, this was the beginning of our effort to resolve this matter back in March of 23. We've taken it to the select board twice. The select board will not agree that it's about, now all select board members will agree that this is a boundary line dispute, but it is because we believe it's in one place and Sharon believes it's in a different place. With that said, the only statutory authority that exists, and in our state it's a Dillon state, so if the statutes don't say that you can, then you can't. Statutes say boundary line disputes are addressed by the select boards. That is a fact. There is no authority for the listers. There's no authority for anyone else, the BCA included, to make those changes occur. We've researched, just to quickly, and I just as a recap, the presumption of accuracy is with us unless proven differently. In our belief, there has been ex parte communication with regard to select board members. Wondering if that's why we don't have but one today. The boundaries have been straight since creation, and there are no adjudications. Ernie has looked into adjudications of the Norwich Sharon boundary line with the Vermont Secretary of State's office, and there are none, and that it's not just one parcel that would be affected should the boundary line change. Now, lastly, we brought forth case law where there was a declaratory judgment previously on record. I put it in the packet regarding if you have a dispute, you have to go to both towns to get resolution, not one town. That's my recap. Ernie, if you'd like to add something more, please.
Well, I'm just looking at it sort of more evidential, countering their evidence. the most important thing is that you've got to remember that the records for town boundary lines are kept at the Secretary of State's office, and as are changes. The law that talks about surveying applies to parcels, not to the towns, because the towns have to have their lines surveyed, but you won't find it in the town's land records. You will find it at the state level in the Secretary of State's office and in a couple other places as well. But I think the formal repository is the Secretary of State's office. Yes.
I'm out of order a little bit here, but so what does the Secretary of State office say about
They
it?
said there's no adjudications, so the boundary line that was established by the Crown in 1761.
It's a straight
It's
line.
a straight line, absolutely straight line, running from a point in Hartford. It runs in a straight line, 60 degrees northeast, essentially. And then stops at a boundary, it stops at a point. It's got 2 points. It's a straight line. 2 points, nothing else. No. The second thing I noticed in the appellant's presentation is the survey they have shows the town line as having a bearing of, well, it says south 51 degrees, 33 minutes, 54 seconds west, which is the exact opposite of the way it's written in the charter, which is north to northeast instead of southwest, but it's the same bearing, just, okay? That's the math. But the point I'm making is their bearing is not 60 degrees. It is 51, etc. So there's a discrepancy between what the charter calls for and what the survey that they submitted says. It says, oh, and it also says that's the approximate town line. It doesn't say that's the town line, because they, there is a discrepancy.
I think, do you all mind, I see several people with hands, and so I kind of feel like we need to go ahead and try to do questions. So I see Tony has his hand raised, so I'm gonna let him ask his question or make his point, and then I see Marcia, and then I know Arlene here does. So Tony, pardon? And
Yeah, thank you. I would like to stipulate that we have agreement with the listers that the BCA has no authority to discuss a town boundary. We are not here to discuss a town boundary today. We're here to discuss double taxation. So we don't really need to focus on the municipal line. We agree that there's no adjudication of the Norwich-Sharon boundary. On the tax maps, it actually waves back and forth. As I mentioned, down in Tigertown, the maps that the listers are using actually bends and ebbs and flows. It is not straight. We also agree with the listers that there's this Poulin case that says double taxation is frowned upon by the law. This is a legal meeting today. We're asking the judge and the jury of this meeting to agree with us that double taxation is not acceptable and to remove it and for the primary source documents to be followed. We also agree with the listers that failing that, a court has jurisdiction, and a court can do this on our behalf if the BCA will not. And finally, in these matters, it's all about equity. And equity is a wonderful body of law that provides fairness unhampered by the narrow strictures of other law. So if the BCA is not willing to provide us with a solution to double taxation, then a court will.
Okay.
Marcia?
Sorry, I've got one other thing to say, Linda, just one thing.
Okay,
The only thing that happened in 2007 was Norwich unilaterally moved their definition of the town boundary based on an updated tax map. That, I mean, on its face, that's kind of, doesn't make any sense at all. So anyway, just the only thing that moved in 2007 was Norwich. Norwich decided, we have a new idea, and they didn't follow any process. So okay.
Okay, and that, I'm gonna put myself in the queue because I do want to pose that question. Marcia, you have a question or comment?
Well, sort of both. I wanted to make the point that there has been no ex parte communication because the issue in the select board brought by the listers was the boundary line. This body doesn't have jurisdiction over boundary lines and we shouldn't be talking about it. We should be talking about the valuation of the property, and how that was determined. The Poulin case, as Mr. Adams has suggested, it's an equity case. And there, what came out of it was the Poulins wanted to join the two towns, and the court remanded the case so that they could be joined. And so basically they were just saying, you know, everybody had an interest. We don't know the result. So I think here I'd like to stick to the valuation, and, you know, I'd be asking questions of the listers. Which comes first? You know, it's a chicken or egg. The law says you're supposed to look at surveys. And so how was the tax map determined in 2007? Did they think that there was a new survey? And, you know, how did they get there? I don't know how many other people were affected, but that seems suddenly there was a 10.4 acre parcel and I don't know where it came from.
Okay, so Marcia, one of your questions sounds like you're wanting to ask the same question I have, which is what happened in 2007 with the tax map? Do you current listers understand why that tax map changed? How did that come about? What was the process?
I don't know that I can satisfy the answer to the question. What we know is that in 2007, there was a revaluation of land. Unimproved land was revalued throughout the town, and there's, I got a document here of all the parcels that got changed assessments. And the only one I saw with a tax map adjustment was the Adams parcel. And that's all I can tell you. I saw the grievance correspondence, and I did not find decisions of grievances, but I did look at the next grant list, and it still was at the 10.4 acres. So my assumption was that it was denied, which in fact we've heard today's testimony that it was. That's what's gone forward since then, and had it been resolved back then, it would have been great.
So if I can just summarize what you just said, I'm understanding you to say that something happened, something did change in 2007. You do not have any factual, substantive support as to like why it changed or how it got changed or on what basis it was changed. You just know that things changed and.
There were a lot of changes that year, a lot of parcel changes, but that one thing is that. I did reach out to, finally found the GIS, stands for the person that was, the business that was doing the tax maps. And I've done this just to see if I can get any more information, and Judy Bond has responded. I made copies of an email exchange that I got last Thursday, Friday, I was out of the office. But it says town lines on parcel maps being different than town lines on the survey is actually all too common, since there was no good source of accurate town line data when digital parcel maps were first created in the 90s. There are a number of towns with overlaps or gaps. If I just give you all have copies, you can have this email. That's the only other information that I have gathered since this.
Yeah, it just says, oops, it happens a lot of towns. Okay.
So I'll give you that for evidence.
All right, and Arlene and Fran have questions.
I guess it was right, because I started reading all this and ended up with a headache. Because it's extremely complicated, so I'm trying to narrow it down to whatever facts we have. And I was glad to hear about 1761, because as I was working, I actually looked to see when were the two towns divided, and it was 1761, and I'm sure we have no records from that. I really did look for it. I just find it fascinating. Okay, so there are some things we know. we know that double taxation is not appropriate and the law says people shouldn't be double taxed. So without a definitive boundary line, double taxation is going to happen because the town of Sharon says X is in Sharon and the town of Norwich says, no, it's not. Y is in Norwich and they don't match. So that seems to me to be something that needs to be resolved, even though that's not the issue that's before us. Because if we say, well, we'll accept, tax maps.
Well, wait, let me just ask you a question, because let's not get into the thinking about the question.
Right, but my question,
I'm sorry if I got you off.
no, you're right, but I'm just really trying to piece together if my
testing.
information is correct.
Mhm.
So if we say 10.4, no, I don't want to say that. If I'm correct, the select board is the only body that has the right to create a boundary line. And I noticed that in the newest future meeting dates and potential topics of the select board, the very first one says Norwich Sharon border.
Point of order,
Yes?
No, it says,
right,
select board, this is future meeting dates and potential topics that I took from whatever it was on the internet.
I think, Marcia, you wanted to make the point you made before, which is,
yeah.
You
In
can-
February,
you know,
So,
in February, we heard it and we heard it again.
I
And
don't reconcile.
it's not supposed to be on there.
wait a minute, so Arlene, I think you don't have a question to ask anybody, any of our witnesses.
Okay, then my question would be, even on the 10 point, even if 10.4 was accurate, which is what you say is in Norwich, we'll do an inspection, but there's also documentation that at least the 2.4 acres are non-developable. So I'm not sure I understand how you would get from what they were taxed to what they are being taxed now, and maybe explain that.
Well, we certainly received the paperwork through the proper channels to get that corrected deed to the office, and I can only refer back to the fact that Spencer Potter was our contracted assessor and has worked in many towns in Vermont and gave us the advice that he gave us in this email, which is what we brought forward based on the fact that he was working for the town. He was our professional assessor and knows more than we know. But we would have looked at the corrected deed and maybe changed something and made a mistake, but his guidance and recommendation was not to do that, so.
Point of order, if I may.
Would
The
have
deed was
been-
never corrected. The deed was never changed. The deed was always the same. The survey was always the same.
Chair,
There
this
were
is
no changes.
Okay, we,
trying to answer the question.
So does anybody know? This is a question of law. If you look at the deeds, and if the deeds don't correlate with what the 10.4 acres are, in what has been transferred, what is it that governs? Does anyone know?
What is it that what?
If the deed says something different than what the listers are proposing in terms of how much acreage there is, I wonder by law which governs.
We are not lawyers, but when we click on the maps on the Lister's webpage, the first thing we see is a disclosure that says these maps are not accurate. For the accurate information, please refer to the deeds and the surveys on file with the town clerk. And any inconsistencies with those primary source documents, please report them up the chain. So our understanding is, under Vermont law, that is the deeds and the surveys are the primary source documents, and everything else should flow from those.
Okay.
I just have one. quick question. I
Fran
really-
has a question, yeah.
It's short. The listers do not determine the map lines but who does? Who has authority to determine that?
I believe it's the
The tax
select
maps,
board.
huh?
Well,
Or the property lines of.
Yeah, you mean are you talking about town boundary lines, or you're talking about parcel lines, individual parcels owned by individual people?
Oh, I'm not sure what I'm. You tell me.
oh, it's a good question. I would imagine that, in most of these situations, a deed and a survey might be the same and might bring forth, a change to a boundary. If somebody had a parcel that was able to be subdivided, they get approval to subdivide it, then they would sell it, and then we would have two parcels under two different names, and that would be what is left. From what we originally had, it's now cut in half, and now we have the two parcels. So we follow those transactions based on property transfer returns that are filed with the town clerk in our town, and surveys that would accompany that, and it would have come from the subdivision request that was made to the DRB initially.
But there was nothing done in 2007. You simply updated your tax maps. There was no division, no nothing.
We are after 5, nobody has come in, so I don't think we're about to be kicked out, and I have two more questions at least. So Marcia and Alik, so Alik, you go first?
I just want to clarify, there's nothing that this body can do about the property lines, right?
Town boundary lines.
Correct.
Right.
So the only thing that we're being asked, if I understand, is the assessment of the 10.4, because we can't change the 10.4.
Yes,
So-
you can.
You can't change 10.4 because you changed it unilaterally in 2007. So you can change it back to 2.4, which would be correcting a mistake made in 2007. You can do that.
Yes, what are you bringing forth to us? You're asking us to look at the assessment of your property, not how many acres there are, because we can't do anything about that.
Ma'am, if you read the one-page appeal document, we ask for two things. We ask that a data error be corrected based on our survey and our deed that the town taxes us on 2.4 acres, that data error be corrected. We also ask that the fair market value be assessed within reason. And I have said earlier tonight what I think that might be. If you agree with that assessment, you will be affirming what the select board unanimously said. They passed a motion on February 14 of this year where they recommended that the listers correct the lister card, the grand list, and the online data to reflect the primary source documents. In effect, what we're asking you to do is to take the recommendation of the select board and pass it today.
Let's.
Not today.
Marcia has, you had your hand raised. Do you still have a point to make, a question?
Yeah, just confirmation from everybody. We have 2 deeds that are at issue. Both of those deeds say there's only 2.4 acres in Norwich. There's only one survey that says that there's 2.4 acres in Norwich. And in 2007, someone in the lister's office did something with tax maps or whatever and decided or heard or believed that there were suddenly 10.2 acres. So I'm just wondering, if that wasn't this current board then of listers, why wouldn't they look, I mean, if they can't find a reason for why the change was made, would they, why are they taking a sudden shift in 2007 with no documentation?
And I think,
That's not a really great recap of what happened. We're working with a contract assessor who guided us and who has a greater depth of knowledge than we did in matters of this, in these instances. So in order to make a change to the total number of acres, it would be aligned with what the boundary line is that Sharon believes is the boundary line.
was Spencer Connors, is that the assessor you're talking about? But that wasn't in 2007. He wasn't doing anything in 2007.
No, but a corrected deed did come to our office.
There was no corrected deed, excuse me. No deeds ever changed.
Are there any, I'm not clear whether we have any more facts that we need to pin down. I think I might say that it seems as if everybody wishes that a VCA in 2007 deal with the issue, and because of communications problems, the grievance didn't end up getting past the listers and all the way to the VCA, and it has arrived to us now, it seems like. Let me suggest that it's time for us to try to schedule our inspection. And a key question is, Michael and Tony, I have the idea that neither of you guys are in Vermont. And is there anybody that, so we have the duty of having 3 members of the BCA come visit the parcel. And is there anybody that can be your agent to receive us?
The Adamses
Yes,
did
ma'am.
give a bunch of dates and times. So if one of you wants to just quickly throw those out, we can let you know if any of those would work.
Okay, thank you.
I didn't forward them on because technically it's the prerogative of the BCA to set the date and time regardless of whether the appellant can attend. But if you want to let Linda know when you're available, then.
Yeah, why don't we start with your availability and then we can find out who, we have to have 3 people from our end do it. And so with a couple of possible dates, then we'll know whether Vermont can match up with you. How about that?
Okay, I'll try to pull up what I sent to Lily. Lily, if you have it handy, feel free to read it out. I'm pulling up.
Yeah,
Oh, here,
hang
I
on.
have it now. I have it. So I offered up, I will be there. It'll be me in person on Chapel Hill Road, September 18 at 3 p.m., September 18 at 5 p.m., September 19 at 10 a.m., September 19 at 3 p.m., September 19 at 5 p.m., or September 20 at 8 a.m. 6 choices.
Okay, we have one BCA member who can do anything on the 19th. Is there, I cannot, so is there enough, we need 2 more BCA members who are available on the 19th. We have 10, 3, or 5 p.m.
Available any of those times.
Oh, okay, so we got 2, we have Elise and Fran, are you available for one of them?
Yes.
Of which?
The 2 afternoon ones.
Okay, that sounds pretty good. So we have 3 DCA members who could be available either 3 p.m. or 5 p.m. on the 19th, right? 3 p.m. is better. I would think so, just in case, it's not dark yet, but yeah. Sounds like we'll need to make. So, okay, so that's good with you. So let's go the 19th, 3 p.m. And the particular BCA members are named Alix Manny, Suzanne Leiter, and Fran DeGasta. And where should they go?
About a mile and a half out Chapel Hill Road North. And I'll be there with, I'll be there parked by the side of the road, about a mile and a half up from Beaver Meadow Road.
And what's your vehicle look like? Is it interesting in any way?
I'll probably be driving a black Ford Explorer, or Expedition, excuse me.
Black SUV? Okay.
Yeah, black SUV.
It sounds like a safari movie. Okay.
With Vermont plates.
Okay. So, okay, good. And then, so we have that. Okay, you guys all you inspection team. So Thursday, the 19th at 3 p.m. And you guys could coordinate, or else you can just meet and drive out Chapel Hill Road.
Yeah, carpool it.
Yeah, you can organize that. Okay, then,
And Linda, just a reminder
Yeah.
that discussions of the hearing are not appropriate at the inspections.
yeah,
Strictly evidence gathering,
right, or it's seeing stuff. It's not taking new evidence.
no comments, yes.
So then the other thing that we have to do, and Lily, we do not have a time for us to get back together as a BCA, receive the inspection report and do our deliberations. Should we try to do that?
Could we recess to a time that will be determined tomorrow when I
Yes.
email you
let's
all?
plan to do
Okay.
that. Right, yeah, I think picking that up via email is gonna be easier. Okay. Yeah.
Recess the hearing
Mhm.
until a date to be determined.
Right, via email, right? Second, can someone second please? Our recess motion? Suzanne, thank you. Okay, all in favor, let's do the roll call. David?
Yes.
Teresa? Suzanne? Elise? Linda, yes.
Yes.
Arlene, yes. Fran, yes. And Marcia?
Yes.
Okay, good. All right, we're done. Thank you very much. Thank you all. We appreciate your dealing with our tech issues, et cetera. Marcia, thank you for your patience.
Thank you.
Thank you.
Goodbye.
Bye.
Leaving this Zoom.